Hey, welcome back, American government class. For the last time this year, it's Friday, May 21st, 2021. Hope you're having a great week. After today, tres más días, amigos. We're almost there. Almost there. Big day today, American government class. 5 things on the to-do list. We'll talk about last class. Then today, we're going to have a judicial branch overview, where we talk about the judicial branch, all of it, in basically one day. We're going to dive into federal courts specifically. So we're going to have basically like 2 sets of notes to take today. Big day. A lot of work. Sorry. Last day of work you'll have, okay? Get over it. Then, final study guide. I'm not going to go over the study guide with you. I'm not going to sit here and go over it with you via video. I'm going to send it to you in the email. So in your email today, you should have a judicial branch overview note sheet, a federal court fun facts note sheet, and a final study guide note sheet. Really, the only one that's important is this study guide one. These other 2 you guys can create yourself with pencil, paper, all that stuff. The final study guide is the biggest one. It's going to have stuff on there from the entire semester that will help you prepare for your test, which is next Tuesday. Tuesday is when we have our final. That's the day. You have all day to do the final. It's kind of a long test, but do your best. This study guide will help you out. All right. If you have any questions on the study guide, email me as soon as today. Email me today. Email me tomorrow. Email me all weekend. Email me on Monday. Any questions you have, just shoot them my way. I will try to answer them all for you. Okay? And then after that, I'll go ahead and give you your attendance and assignment. So let's start off. Last class review, we talked about the President's Cabinet, also known as the executive departments. Great job. Those of you that sent in the work, we were talking about secretaries galore, right? Secretary of Defense, Secretary of Treasury, Secretary of Urban Development, Secretary of Housing and Urban Development, all the secretaries that you can imagine. All of these people are there to help the president out. We also talked about Air Force One, First Lady, White House, all that good stuff. It was a long video. Hopefully today's isn't as long. But it was a good presidential trivia wrap-up, if you will. We are done with the executive branch. No test for you on that. All of your test questions will just be on the final. So you will be tested on it. It's just going to be on the final. And that's that. So today, judicial branch. Now, let me give you a quick intro before we go over the judicial branch. Normally, like I said a few classes ago, this unit would take 2 to 3 weeks minimum. We'd be talking about a lot of different court cases. We'd be understanding how courts work, the differences between federal courts and state courts. We're going to try to wrap it all up in there today. There's so much more than just what I'm going to tell you today. I wish we had more time. I apologize for the conditions that we were under this year where we don't have that time. But it's still important to talk about the judicial branch because a lot of people think it's not that important. You have the executive branch, which is the president. You have the legislative branch, which is Congress, the Senate and the House. They get all of the publicity. But when it comes down to it, a very strong argument can be made that the judicial branch is the most important and most powerful branch of government that we have in the United States. I'll try to clarify that today when we go over our notes. So, for right now, take a look in your email. If you have note sheets for the judicial branch overview or for the federal court fun facts, actually, federal court fun facts, I don't think you'll have one in there. You're just going to go ahead and take down these notes on paper. There's no outline. Judicial branch overview, you should have one. So get that out of your email. Get another piece of paper. You can just use the back of this paper for the federal court fun facts. And let's go ahead, take a look at our judicial branch in one day. All right, guys, so here's our first note sheet that should be in your email, the Judicial Branch Overview, Cornell Notes. Also, I know I said that you wouldn't have that Federal Court Fun Facts one, but you're going to have this in your email as well. So they're both Cornell Note style. You can print them both out and just fill in the notes accordingly. But we're going to go through it this way on my screen just to save some time, make it easier for you. So, first and foremost, the principles of the U.S. legal system. That means, if you recall, when we talk about principles, what is it based on? What are the leading factors? What things contribute? What are the main beliefs of the judicial branch or of our U.S. legal system. And the first one goes back to our Constitution and the Equal Protection Clause. The main idea, or the first principle, I should say, is equal justice under the law. That is the number one principle. And that just means, very simply put, that everyone should be treated equally under the law, no matter what color your skin is, no matter what you believe, no matter who you love, no matter how tall you are, or any other crazy things. Equal justice under the law. It should be equal for everyone. The second principle is one that we know very well: due process of law. And of course, this goes back to our constitutional overview too. And if you recall, this is the principle that the government must follow proper procedures for all individuals. And that's to say this: if you are going to give me a lawyer and a court case, you must also get a lawyer and a court case. You get a judge, I get a judge. The government has to follow the same procedures for everybody. You can't skip out on giving somebody a lawyer because you don't like them, or you can't skip another process in the legal system because you don't like them. Everybody is due the same process when it comes to being under the judicial branch or a court case of any kind. The third is something called the adversary system. And maybe you've heard this word adversary. It kind of means like, you hear it a lot when you say like, hey, friends, adversaries, opponents, who you're going against. Basically, it's a judicial system in which opposing lawyers, so lawyers who are against each other, and let's go ahead and let's correct that. Judicial, thank you. In which opposing lawyers present the best arguments to an impartial judge. And you know, we're going to shrink these down a little bit, guys, just so that our notes still work out properly. We'll just zoom in a little bit here. There we go. So the adversary system basically means that both sides in this judicial system are going to have lawyers who present the best possible case for each side. One side may be right, one side may be wrong, but lawyers are going to present the best arguments for both sides that they possibly can. You're not going to get a lawyer, or you're not supposed to have a lawyer who doesn't present the best argument for you. And you should also have an impartial judge. And then finally, the fourth one is probably the most important. You've heard it before, I'm sure. The presumption of innocence. And that can be phrased up in four short words that I'm sure you've heard in many TV shows, movies, or, books. This is the idea that you are innocent until proven guilty. You must be proven guilty. You are not ever considered guilty until somebody proves it. Back in the day, this was not the case. You were considered guilty until you could prove that you were innocent. That is clearly not fair. So, in modern times, we have made changes. We have gotten better. And we have this legal principle that says, no matter what you are charged with, no matter how the evidence is stacking up against you at the beginning of a trial, you are still innocent until you are proven guilty. We must presume that you are innocent until someone shows us otherwise. Those are the four major principles of the U.S. legal system. Make this guy a little bit smaller as well. There we go. All right. Now, when we talk about the U.S. legal system, there are two different types of jurisdiction that we need to talk about. Jurisdiction, if you would have had vocab this unit, if we had time for it, you would have learned that that's basically the ability to hear a case. It means you have the right to hear a case. For example, I have jurisdiction over this school. I have the right to create rules, to create events, to give teachers assignments. I have that right because I have jurisdiction over this school. This school is my jurisdiction. I cannot do those things for another school. So that's what jurisdiction is. Now, we're going to talk a little bit about jurisdiction in a different way, and that's going to be original and appellate. And original jurisdiction basically means it's talking about the first time that a case is heard. And this is going to be in trial courts. So when you go to trial, original jurisdiction means, hey, this is the first time you've had a lawyer, the first time lawyers have presented against you, the first time there's been a judge. This court has original jurisdiction. They are the first to hear you. Appellate jurisdiction is a little bit different. These are cases that are heard on appeal from a lower court. Now, when I say lower court, that's one thing that I want to talk to you about today, guys, is that there are different levels of courts. There are tiers, if you will. There are lower courts and there are higher courts. And the point of this is so that you can appeal different rulings. We always hear about how court cases take a long time because people always appeal the outcome. Just because someone is found guilty of a crime does not mean that that case is over right then and there. You can still appeal that verdict. A verdict is the outcome, basically. So when we hear about original jurisdiction, that's the first time that a case has ever been heard. And appellate means, hey, after this original jurisdiction was held and they had the case the first time, people are now appealing. And that's where you get the word appellate, appeal. From a lower court, they're saying, we want to take this up to a higher court that's more prestigious, that's stronger. And we want you to hear this same case again because we think that they got it wrong the first time. Now, we'll shrink these down a little. Let's do this. That's boom, boom. Now, when we talk about federal courts, remember there are federal courts and state courts. When do federal courts have jurisdiction? So we have, just like everything else in our form of government in the U.S., we have two tiers. We have the United States and we have individual state governments. We have a president. Each state has a governor. We have a United States Senate. Each state has a state Senate. Just like we have that division in the executive branch and in the legislative branch, we have it in the judicial branch as well. We have federal courts and we have state courts. Now, federal courts will hear cases that involve things like U.S. laws or the Constitution. Obviously, those are United States things, so they would have jurisdiction over any case that involves U.S. laws or the Constitution. Another would be any treaties that our country has signed. They also have jurisdiction when there are representatives, reps, of foreign governments involved. Anytime we have maybe an ambassador from another country, or if there's a leader from another country involved, they are somehow representing another country, a foreign government, and there is a court case that somehow involves them, that would be a federal court jurisdiction. Another is maritime law. And we remember maritime. Maritime means out in the ocean. Anything that happens between boats or any conflicts that take place in the Atlantic or the Pacific, Indian Ocean, things like that. Anything involving maritime law, the U.S. federal courts would have jurisdiction. Also, and this is what happens most often, disputes between states. California and Arizona are oftentimes fighting over water. The federal courts would have to get involved between the California and the Arizona governments if they were having a dispute. A federal court would have jurisdiction. And then finally, the last one, where a federal court would have jurisdiction, is if it involves a U.S. government agency, so the CIA, the FBI, the Department of Homeland Security, or an official, meaning a senator, a president, a judge, any type of ambassador that we have that is an ambassador of the United States to another country. Federal courts would have jurisdiction over those cases. Go ahead, shrink this down a little bit as well. Whoop. Now, there are state courts, like I said. When do state courts have jurisdiction? Well, that, my friends, is very easy. Whenever there are cases involving, and let's just say Arizona, for example. So we'll say, when does an Arizona court have jurisdiction? Anytime the case is involving a state law or the Arizona Constitution. That's right, each state has their own constitutions. If you remember from Unit 2 all the way back in 2020 when we were talking about this, each state has their own constitution, just like the United States has its constitution. But the Arizona courts have jurisdiction whenever there's a state law or an Arizona constitution. And this is where we talk about one of the most important things I think you learn in the judicial branch unit. And that's the difference in cases. When we're talking about the judicial branch and court cases, there are two types of cases. There are criminal cases and there are civil cases. A criminal case is when you commit a crime against the state, meaning you break a state law. If you break any kind of law, if you're speeding, if you commit murder, if you are embezzling, anything where you break a state law, that is a criminal case. That is a reason you would have to go to court, obviously. However, the other type is a civil case. And we talked about this a little bit in the Constitution unit as well. A civil case is usually between two or more individuals. So maybe you are getting divorced. That would be a civil type of case. Maybe you have a dispute over land. Hey, this is my land. No, this is my land. And you need to have a court rule upon it. That would be a civil court case because you did not commit a crime against the state. If you are being sued, that is a civil court case. I would go to a civil court. I'm suing you for doing this or for this reason. Maybe you didn't break the law because you didn't commit a crime against the state, but you're being sued for some reason. That would be in a civil court case. So very important, those two differences, the difference between criminal and civil. Scoot that up a little. And then the last part of our notes today, at least for this section, is selection of federal judges and justices. So there are absolutely higher courts, higher federal courts. The highest court we know in the land is the Supreme Court, and the people that serve on the Supreme Court are called justices. But when we are talking about how you get to be a federal court judge or a Supreme Court justice, this is it should be a review of what we went over in the executive branch and the Constitution unit. The first thing is the president nominates them. Remember, this is where the president gets to pick whoever they want. We said this is the case for federal judges, Supreme Court justices, ambassadors, and for all cabinet positions. The president gets to nominate them. They pick who they want. However, it doesn't stop there because, as we know, they have to be confirmed. Anytime someone is nominated, they must be confirmed. And who are they confirmed by? That's right, Senate confirmation. The Senate confirms them, or they do not confirm them. And if the Senate doesn't confirm them, that person does not get the job. However, with judges, federal judges and justices, if you remember, they have a lifetime appointment. They don't have a 8-year limit or a 2-term limit. They are appointed for life, specifically so they can't be pushed upon by anybody to change their views. They don't get, they won't have people weighing on them, telling them to do something and saying, well, if you don't vote this way, we're going to fire you. And that is a huge, huge reason why you have the lifetime appointment. It's the idea that you are protecting the judges and allowing them to vote how they want in a case freely. They have no pressure upon them, public or political. So they are appointed for life. And then finally, a federal judge or Supreme Court justice, this goes along with it, cannot be fired per se, but they can be impeached, meaning Congress can go ahead and impeach them, start the process, just like the president. When we talked about impeachment, Supreme Court justices and federal judges can go through that same process. So remember, they could get impeached, which means to be charged, and then there would be a court case where the Senate would hear the case. And if you're found guilty, they would be removed from office. So that is it for our judicial branch overview. It is a very brief and quick overview. Let's go ahead over to the federal court fun facts page, and we'll make this one quick as well, so we can get you guys out of here, get you studying that study guide. For judicial review over here, this is something we've talked about in the past. It is one of the 6 principles of our Constitution. It is a huge, very powerful piece of, not information, it's a very powerful power, I guess, a responsibility that the courts have. And that is let's make some bullet points here. The power of a court to declare laws or executive orders to be unconstitutional. So, if a law is created or if an executive order is written by a president, right here, judicial review, courts can declare them unconstitutional, meaning they just don't work. They are not allowed. They are null and void. And this goes back to a very important court case called Marbury versus Madison. And this set the precedent for judicial review. Now, precedent is not the word president, it's precedent. It means something has happened in the past, so that is the standard. This court case, if we had more time, we would have dove into the entire case and we would have studied it. But it was a court case that happened in 1803 that involved President Adams. It involved another person to become president, James Madison. And basically, this case is the reason why courts are allowed to go back and declare laws unconstitutional or executive orders. Now, when it comes to the courts, slide this down a little bit. give another bullet point. There are two courts that I want to talk to you about when we're talking about federal courts. The first is obviously the highest, the Supreme Court. And we know that this is established by the Constitution. When the Constitution was written, they created the Supreme Court. Why can't I spell today? Constitution. The lower courts, come on, there we go. The lower federal courts were all established by acts of Congress, meaning the legislative branch created them, said, hey, we need to have a court to go over this thing or for this reason. So they passed laws to have these lower federal courts. We got there. It's a small font. We'll zoom in a little. And we got big bullet points. That's fun. Okay. In fact, why can't we do? Whatever. This will just have to work for now. So now, the justices and judges, as we just talked about in our last notes, and don't worry, I'll change the size, are appointed by the president, confirmed by the Senate, and they have a lifetime appointment. Now let's try to shrink all this stuff again. Weird how these two guys are still big. Whatever. Now when we talk about the Supreme Court, this is some very important stuff that we'll get through really fast here. Let's just go another bullet point. There we go, decent size. The number of Supreme Court justices is also determined by Congress. Right now, this should be reviewed. There are 9 justices at the present time. There is a lot of talk about creating more justices, and that would be the power of Congress to do so. We've had 9 for quite a while, but right now Congress is discussing if we should add more justices. And remember, the only way to remove them from office once you become a Supreme Court justice is impeachment. See if we can just make this all size 12, including those. Boom. Of course, this bullet point doesn't work. Whatever. Now, the leader of these 9, the head of the Supreme Court, is called the Chief Justice. And the role of the Chief Justice is simply that they are responsible for the operation of the United States Supreme Court. They set the agenda and discuss list, meaning the cases that a Supreme Court hears. The Supreme Court is basically an appellate court. They hear appeals from lower courts most of the time. The Supreme Court gets to decide which cases they want to hear. They take a look every year at what cases they want to look at, and they have the final say. The final say on this case. Once it gets to the Supreme Court, the verdict cannot be overturned. So the Chief Justice gets to decide what cases they hear, they help decide what cases they hear. The Chief Justice sets the agenda for how they will hear cases, how things will proceed, and things of that nature. Make that 12 again. All right. Now, when talking about other justices and the factors that shape Supreme Court decisions, meaning what do justices, how do they decide in a Supreme Court case how they're going to vote? Well, the first thing which is, similar to everybody, is that it will come down to the justices' personal views. Ideally, they have decent personal views because they've been judges for life. They've been appointed by a president, and they've been confirmed by a Senate. So we are led to believe that most justices have good personal views, and we trust them to create the right verdicts. They also, however, look at existing laws. What laws exist already? They can help them make a decision on this case. And then finally, that word we talked about earlier, legal precedent, which basically just means, again, decisions in previous cases. So they will see how previous courts, previous judges have ruled, and then they will decide whether or not they will agree or disagree with those rulings. Now, when it comes to Supreme Court rulings, they are reached by a majority of justices. Just like everything, for the most part, that we do in our government, you have to have a majority to vote a certain way. Now remember, there's 9 Supreme Court justices, so if 5 vote in one favor and 4 vote against, the 5 have it, majority rule. The majority of those Supreme Court judges get their outcome. And this outcome is binding on the lower courts, meaning all the lower courts must now basically take their verdict as law, as there's no appealing. All the lower courts must see up. Well, the Supreme Court ruled on it this way. That means that we are going to have to view cases this way from this point out. They gave us the guideline. And for the most part, it is the final decision on a case. There is only one way a Supreme Court decision can be overruled, and that is it's the final decision unless a future Supreme Court decision overturns it. Meaning the Supreme Court does have the power of judicial review to overturn decisions it has made in the past. If they don't do that, however, its ruling is final. And one last thing I want to talk about that's not on these notes, but we'll just add it right here. If you vote, let's say we have a nice little Supreme Court. There are 9 judges on it, 9 justices, as we know. And there are 5 that vote for and 4 that vote against. Doesn't matter what the case is. When they reach their verdict, they give something called the opinion of the court. And that, here we go, let's just put this in here. Opinion of the court. And that's basically that didn't work out well. A written document that states the facts. It announces the ruling, and it explains the reasoning of the justices. This is very important because this is where we set precedent for other cases. Now, one thing that it gives, if all of the justices don't agree, is it gives the majority opinion. And that's what it's referred to. The majority of the people felt this way. This is how the majority feel about this case. They write a little statement. That's called the majority opinion. Now, the people who disagree with them write something called a dissenting opinion. And that is their explanation of why they feel the Supreme Court justices that voted in the majority are wrong. And there's one final opinion that can be given, and that's for these people in the majority. If they agreed with the reasoning, or if they agreed with the outcome of the case, but not for the same reasons as the others. So let's say it was still 5-4, but one of the people voted in favor, but not for the same reasons of the other four, and they wanted their voice to be heard. They give what's called a concurring opinion. And that's like saying, hey, I agree with them, but for a different reason. It's like if you're with your friends and you say, where should we go tonight? And they say, it's 9 friends. 5 say, want to go to a movie. And you're one of the 5 that say you want to go to a movie. And 4 of them say, because this new movie just came out. But you were thinking, hey, well, I want to go see a movie, though, because I really like the ice cream machine at the movie theater. I know that's a terrible example. Nobody loves an ice cream machine at the theater. Let's scratch that. Maybe you know that there's going to be a cute girl or a cute boy going to the theater that night too, so you want to go too. You concur with the opinion, but for a different reason. You don't care about the movie. You had something else in mind. And that's what a concurring opinion is. All right. My friends, that is it. That is our judicial branch overview in one day. Again, there's so much more I wish we could have gone over, but this will have to suffice. So please send me these notes of federal court fun facts as well as your judicial branch overview today. And go ahead and work on your study guide. But this is it for what I want you to be sending me today. The judicial branch overview and the federal court fun facts. Let's go take a look now, at a deeper look, I should say, for your assignment and your attendance. All right, y'all, that's it. A lot of information in there today. We'll make it easy for you for your assignment. Very simple. Today's assignment, send me your judicial branch notes, both sets, the judicial branch overview and the federal courts fun facts notes, and then work on your study guide. I'm not going to say complete it and send it in to me because that's a lot for one day. I want you to start working on it. Today's Friday. I know it's the weekend, but try to take a look at it over the weekend. Just get it in your head, maybe while you're eating breakfast or lunch or anything. Just take a look at it over the weekend. Just pull it out. Maybe right next to when you're eating. Maybe you accidentally glance over at it and see something. I don't know. But work on your study guide. Try to work on it this weekend. Work on it on Monday. Just work on it. Try to complete it by Tuesday so that you're ready for the final. But you don't have to send me anything regarding your study guide. Just send me your judicial branch notes, both sets of them, for 2 days assignment. And that's that. I will see you guys on Tuesday for the last video that we have for this class. Looking forward to it. I'm sure you are as well. You guys have a great rest of your week, a great rest of your weekend, and we'll see you on Tuesday. Take care.